This is what it's like to represent somebody charged with the death penalty in Florida. And once again, we're talking about state court. The first thing you're going to do in the case is, of course, interview the client. And in Florida, the rules in a death penalty case require two attorneys. Over the years, the courts have required that two attorneys be involved in the defense of somebody charged with a death eligible case so that the courts are confident that they're getting competent representation. So we have two attorneys. We interview the client, and then we start investigating the case. And in a death penalty case, you're not only investigating the facts of the case itself, but you're also doing a very thorough investigation of your client's background. And that includes medical history, that includes mental history, that includes school records, that includes military history, if there is any military service on the part of your client, that includes criminal record or the lack thereof, that includes involvement with religious groups, with civic groups, anything you can think of. And you want to get records. You want to get records of your client's life story, basically. What you want to be able to do in a death penalty case is to tell either the prosecutor or the jury in the case your client's life story, and you want to be able to explain and convince the jury that your client's life story is such that your client does not deserve the death penalty if you reach that stage. And there's, as I said, one of the things that you're doing in a death penalty case is you're also preparing to approach the prosecutor, because in the state of Florida and in most jurisdictions, I would imagine, the prosecutors have a lot of discretion in deciding whether to seek the death penalty or not, because the judges are going to want to know pretty early on in a first degree murder case where the death penalty is still on the table whether or not this is actually a case in which the state will seek the death penalty. And then part of the investigation is designed to convince the state or the prosecutors that they should not seek the death penalty. And I've been pretty successful in doing that over the years. I had a case just recently where the state, the facts were horrendous. My client shot his girlfriend basically 24 times with an AR-15 in their house and shot her in the back. And there was quite a bit of evidence, including his confession to the police, that would show that he was guilty. And there were when we got the case, our fear was that the state would seek the death penalty, but we immediately conducted psychiatric investigation. Our client's family hire a very qualified psychiatrist to go examine our client, and we were eventually able to even keep the state from filing first degree murder charges because of our ability to present evidence to show that our client, whatever his state of mind, was under some serious psychiatric influences at the time that the killing happened. And so they ended up charging second degree murder. We kept that from being a death penalty case. I've had other cases where I have conducted an investigation that lasted months, because we're getting all the records and we're getting everything in our client's background that we feel could be used at a death phase in the trial to show that our client did not deserve the death penalty. In other words, mitigating evidence. And after I did all that, I prepared a 20, 30-page memorandum with exhibits and other evidence, and submitted it or sent it to the state. And this one was in Miami, and they have a regular procedure that they use in Miami in the state attorney's office to decide whether or not to seek the death penalty in the case, and it involves basically having a meeting of the top prosecutors, and they'll go over these cases. And so, at any rate, I was able to convince them not to seek the death penalty. And in that case, they still went forward with the first-degree murder charge, but it was a non-death penalty case, which is, of course, like I was saying, the judges want to know that because death penalty cases have special procedures that have to be followed in Florida and in most states before the actual trial. That case, we ended up working out a plea, and I think my client's actually out of prison now in that case. I have a case right now that we're working on that is a very involved case. And that's the other thing about these death penalty cases is that for the attorneys, they're very time consuming. If you want to do the case right, because it's the ultimate penalty, and you have to do your job well in the case in order to for your own professional satisfaction, as well as knowing that you've done the best job possible for your client. And these cases are also, if somebody gets the death penalty, the cases are scrutinized by the courts in very minute detail for many, many years after the sentencing hearing. I had one case, very early in my career where my client did get the death penalty, and it was a horrendous case where the victim was related, the daughter of a high-ranking City of Miami police officer. The evidence showed that she was tortured, sexually assaulted, and then thrown off a 71-foot bridge over the intercoastal waterway. And my client was one of, I believe, 4 or 5 people involved in this. That case, though, was reversed on appeal because, as I said, we'd done a lot of work. And my partner in that case, there were 2 attorneys, as I told you, and that my partner in that case is now a sitting circuit court judge. Very, very good judge, too. And we did a lot of work in that case, and eventually the appeals court agreed that the client did not deserve the death penalty, even though the facts of the case were just horrendous. But what happens is you have to really devote your life to protecting your client's life. At the same time, the lawyers can't get too involved in defending your client because it will drive you crazy. You have to have a certain distance between you and your client, but at the same time, you have to do everything you can to protect their legal rights, and not always successful. I mean, there's some very good attorneys who've had clients go to death row and get executed, and that's usually because the evidence is pretty bad. But that's one of the issues I have with the death penalty is that it almost seems like we're spinning our wheels to a certain extent. And when the lawyers are working that hard on the case, and most of these cases end up being court-appointed cases, even though the ones I was telling you about, that recent case was not. That family was able to hire 2 attorneys, but very few people in that situation are able to hire 1 attorney for a death penalty case, let alone 2. But what happens is that it becomes very costly for the state of Florida. So financially, death penalty is kind of a loser for Florida. And just in those terms, I see in the future the trend being that the death penalty is probably going to be abolished, because of legal reasons as well as financial reasons, and also for moral and cultural reasons, because the trend around the world seems, in the what we call the Western countries, is to not have the death penalty on the table. But while it is on the table, we have to stay on top of it. And that's another thing about death penalty cases, is that if an attorney wants to represent somebody in a death penalty case, you have to meet certain standards established by the Florida Supreme Court, which would involve prior experience, as well as continuing what they call continuing legal education, which involves going to seminars where lawyers are instructed on the latest developments in death penalty cases, as well as on your own keeping a track of all the major developments in the death penalty, because it is a very complex area of the law. So really, I think the Supreme Court wants to make sure that the most qualified and competent attorneys are doing a death penalty cases.